Hey everybody, welcome back to the channel. Today on John's Briefs, here again with national leading expert witness, Carrie Dudenhofer of Carrie Concealed. She asked last week for us to talk about what are some of the cases that we have had as expert witnesses with some stank on them. Today we're going to talk about it.
Firearms Legal Protection is who I trust to help me after a use of force incident. If you're a Firearms Legal Protection member, you can attend our monthly active self-protection training seminars for free. Check out all they offer to their members at the link below.
So Carrie, funny stuff. I shared in a previous video, right, that we did on this topic of expert witnesses that the thing is I had an attorney or paralegal go, "Oh, John, adult words coming. Oh, John, I'm so sorry for inviting you to this shit show." And I was like, dude, that's the only kind of show I'm welcome to. Like, by the time I get hired, it's because the attorney goes, "Oh, dang. Okay, I need some help here. Oh, dang. This is stinky." The super easy cut and dried one, right? Like Eli Dickens, who stops a mass killer in a mall in Indiana. You don't need an expert witness to explain that to a jury or to a prosecutor, right? The attorney's going to look at the prosecutor and go, "Bro," and the prosecutor's going to go, "Thank you very much. Here's your key to the city. Here's your free beers for life at every restaurant in town, and have a nice day." We get called for the goofy ones.
It's so true. And some of the ones that the whole thing, I had a very wise person tell me early on, initially, you don't need to look at everything in discovery. Initially, I mean, you do eventually, but initially, look at the, whether it's 2 to 3 seconds or 5 to 10 seconds where the encounter actually happens. Look at that first, because if that isn't a justified use of force, the other stuff doesn't even matter. So look at this first and then see, and then, build out from there. So sometimes that might look just fine. It's when you go looking at the other stuff that you're like, oh my goodness gracious. Like your case out of Michigan, for example.
My case out of Michigan is absolutely one. So I guess we'll lead with that one, right? So
sounds good.
This case, it's been adjudicated. It is going to go to appeal. Okay, so you can look it up if you're in the ASP Unlimited app. Please watch my testimony in that case. And I'll tell you, I'm going to be straight up with that because I was so last minute, and because of the way that this was, I think the judge made a terrible mistake and did not allow an expert witness to testify in use of force. Would not allow it. And so I wasn't allowed to testify in the use of force. It wasn't about me. The judge didn't allow that, even though the prosecutor absolutely used justification negation as part of his prosecution. And so I have a feeling that they're going to get an appeal on this. And if they get an appeal on it, the prosecution, if they have a brain in their head, will drop it. Because next time they're going to get an expert in self-defense, and we're going to beat them with a stick. Anyway, in the kindest way, in a legal sense, right? We're not talking about a literal stick. But if you look at that issue, right? So you can look it up. It was out of Ann Arbor, Michigan. And so in that particular one, I got hired. And when I first started watching the discovery, what happened was we had a breaking and entering into someone's shop and into their place of business. And the defendant then grabbed his .300 blackout AR pattern pistol and ran to his shop, which was also his place of business, to stop the breaking and entering. It ended up being by at least 2, might have been as many as 4 individuals. He then goes in the door of his shop. He's got a big roll-up door on the other side that they had rolled up, and we're trying to steal things out of his shop. He sees the first guy. The first guy freaks out when he sees him and runs off. So he doesn't shoot that guy. Okay, fine. He said, I had the skill to shoot that guy, but he was running. I didn't need to shoot him. That guy then jammed out the door and beeline for the highway. Feats don't fail me now. So he ran out to the same place where that guy had come in, watched him run off, and then realized, oh no, there are more people here. And turned back to look inside of his garage, didn't see anybody there, turned again and saw another person who had broken and entered in the shadows, like 4 o'clock in the morning, crouched 10 feet away from him. And he said, for sure, I was a dead man. I knew he was going to kill me right there, and he had already gotten me. Raised his AR pistol up and shot 6 times, and that man died right there on that scene. Then our defendant ran off a little bit, see who else was out there, make sure that, he had 2 girls in his house, see who else was out there. A few minutes later, realized that everybody else had bugged out. If there was anybody else, went and checked on his girls, went and the product that they were stealing was temperature sensitive. They stole it out of freezers. It was medical cannabis. And so he loaded it back into the freezer because it was going to ruin $40,000 worth of product. Okay, so far so good. Here comes the stink. The stink is that in that interim time, he decided that, you know what, that guy who ran off isn't going to call the cops, and the cops hate me because I'm a weed farmer. And every time I call them for help, they don't help me. And I am mad about the way that they have treated me. He's part of communities where in cannabis farming, where, I mean, armed robberies happen and the cops won't do anything about it. Happens all the time. And I'm talking $50,000, $100,000 in cash and products stolen at gunpoint. So he decides, you know what, that dude's not calling the cops. I'm not calling him either. That's a big mistake. Okay. Then he made a bigger mistake, and he then decided to get his tractor with the front bucket on it and scoop the body up and put it on his woodpile and burn it. That's a bad idea. Okay. That's what they call the desecration of a corpse and a violation of the human sanctity, and also failure to report a death. And so he was convicted of both those charges. And the desecration of a corpse is a felony charge. So, and when I started on that case, I told the attorney and the paralegal, I'm like, guys, I don't know that you have a defense for that, other than he lost his dang mind, other than, hey, under the stress of adrenaline and cortisol and epinephrine in his system, that he did a wrong thing that was stupid, but he was temporarily insane, maybe. I'm like, but as far as justification for doing that, it just doesn't exist. So yeah. And so that one, that's why I got invited to that one, because of course the prosecutor looked at that and went, ew, and then ended up charging with murder and charging with felony firearm and charging with illegal possession of a short barrel rifle, which we got the illegal possession of a short barrel rifle charge, a not guilty verdict on that. So that was the only thing I was allowed to testify on in that case so far. And when the appeal hopefully is granted, which I think it will be, the appellate attorneys really think that the chances of it not being granted are very slim. They think that it's overwhelming evidence that it should be granted because of a couple of egregious errors made in that case by the judge. So anyways, we'll see how that goes. But that one was obviously a, wait, what? So yeah. How about you, Carrie? What are some of the things you've seen?
Well, before we do that, I'd like to go back to, for just a minute, the part about the judge's terrible mistake and not allowing defensive use of force expert to testify. It's interesting because I think most concealed carry permit holders or most responsible citizens think that they have, of course, they will have an expert testify. I mean, if you're part of firearm legal protection, for example, they pay for expert witness services. So that must be something I'm automatically allowed by law to have. And when a police officer is on the stand, their defensive tactics instructors are there to testify. If you have a medical malpractice case, then you're going to have a medical expert witness testify. So it seems like it should be a standard, but it isn't in this space. And I don't understand why that is. And it's a pretty big trend, actually. Yeah. I don't want to say more often than not, but in my area, well, I should say in my half of the country, not so say half, in my corner of the country, it's happening frequently, where the defensive use of force expert witness is absolutely qualified, has been court qualified, court approved, disclosed in many other cases, and yet they're still not allowed to testify.
Yeah, sometimes and what I've seen this one wasn't about me. It wasn't about, well, we won't allow this person to testify. Some of it was because they changed who the expert witness was at the last minute. So I was a last minute disclosure. And so they didn't give my reports to the prosecutor until literally it was like a week before the trial started. And so then the prosecutor, of course, freaks out and files objections and, we can't allow this. And the judge laughed him off about the firearms issue. Like, no, he's coming in to testify about the firearm issue. Like, there's nothing you're going to do about that. And then held in abeyance, like didn't say no, but said, well, if you bring up self-defense at all as a prosecutor, then I'm going to allow it, but I'm going to hold it in abeyance. So the judge kind of like sailed between Skyla and Charybdis on that. And then even though he did multiple times, and even though the defense attorney objected and said, hey, I want my expert to be able to testify in that, the judge then said, no, we're only going to allow that one bit. And that was a pretty egregious error. And the appellate attorney agreed that was a very egregious error. There was a couple of other errors in there that were pretty big, because given the facts in that particular case, they should have. But you definitely need, as an expert witness, and your attorney needs to know how to get an expert admitted. And what I normally tell attorneys is like, the way you got to put it to the judge is, and of course I learned this from Asada Youb, it's not me, is just like if we were in a medical malpractice case, we would need somebody to educate the jury on what's the normal standard of care. What kind of disease are we talking about here? What's the normal pathology of that disease? What would we expect a professional to be able to see and understand? And what is the standard of care that we would expect? So then they basically, the expert sets the strike zone, is what the expert does. And then the other testimony is what the jury determines to say, here's the strike zone. Was this a ball or a strike? And so that tends to be a pretty good argument to a judge that, hey, my job here is to set the strike zone, and we want to educate on what the actual issues are. In my case out of Michigan, it didn't have anything to do with, well, people should be able to understand this, it's easy, whatever. It was the prosecutor objecting because I was disclosed so late. And the defense attorney basically couldn't overcome that objective in the judge's eyes. And so the judge was like, well, I hear you. And so again, and now on appeal, it's, hey, the defendant is supposed to be who gets every benefit of the doubt here, especially in a criminal case.
Right.
And the opportunity to present the most robust defense that they have available. And so if ever this comes around again, I think my hope is that the appeal is granted. It should be. I think the case there is very, very strong. And then hopefully the prosecutor has a brain in their head and doesn't recharge. I really hope so. If he does, I'm going to get admitted the next time, because we'll have plenty of time. And if that happens, I'm going to set the strike zone. And once the jury sees the strike zone, it was very clearly a justified use of force under Michigan law. So much so that the jury was actually deadlocked for 5 days. And then the judge would not, even over 4 objections, the judge would not tell the jury that they could come back deadlocked on a charge. And because the judge would refused after 4 objections to tell the jury that they could come back deadlocked on a charge, one of the jurors, the one juror who was holding out and said not guilty, said to the defendant and is testifying by affidavit to the appeals court that they bullied her enough and called her enough names that she agreed to flop on a lesser charge. And so that's what we call a coerced verdict. And when they absolutely could have and should have mistrialed on that charge. And so they absolutely should have mistrialed on those charges. So anyways, that appeal will likely be granted. And then we're hopeful that the prosecutor realizes, because actually the defendant was acquitted. They were charged with open murder, but convicted of voluntary manslaughter. So these 2 bigger charges, the lesser of voluntary manslaughter. So if the appeal happens, these 2 charges of murder have already been decided not guilty. So they can't be recharged as murder. And the facts of the crime don't remotely fit a voluntary manslaughter instruction. So like, this couldn't be that. It literally couldn't. Yeah. So anyhow, what a mess.
One of the cases, in one of the cases that I was involved in, the reason, and it wasn't, like you said, it wasn't that the judge said no to you as the expert. It was the judge says no to an expert, period, in this area, because self-defense is common sense. And the jury is a smart jury, and they have common sense, and they should be able to, or they'll be just fine on their own, which is interesting to me that it's that's the view, and that's what the prosecutor put forward, and that's what the judge agreed to. And again, stuff comes back on appeal when things like that happen. But it's just interesting to me the gymnastics that have to take place, and all the motions in limine to get the expert booted before the trial even starts. I was an idiot when I started doing this work, and I actually thought that there was justice in the legal system, and that of course the prosecutor in any jurisdiction would be fine if the expert testified, as long as it's a qualified expert and court qualified. Of course they would allow him to testify, because the prosecutor wants to see justice served, not win for a record or because it's an election year or that type of thing. And anyway, I won't go on a rant, but that it just gets distasteful after a while.
And okay, so allow me to play devil's advocate just a moment on that, right? Because one of my things is I'm always trying to go, okay, so are most prosecutors scumbags? No, I don't think so. I think most prosecutors are decent humans. So I think most of the time, of course, they're gonna allow that, all right? And that's why I think most of the time we get either dismissals or plea agreements. Hey man, you did this thing wrong, and I'm gonna catch you on that thing, and then I'll dismiss all this other stuff. So I think that's why 96% of the time, right, we end up in a plea agreement or a dismissal. And it's these ones that stick in our craw that we have this big difference of opinion. And I wonder sometimes, like I have friends who were prosecutors too, or were prosecutors for a long time. And of course they see on the other side, well, they just hired somebody that agreed with them and would say anything they wanted them to say. And so that doesn't sway me, because, I've seen too many times where the defense guy is a scumbag trying to get a scumbag off of charges that he should be convicted of. And so, they play that off each other. And of course, those negative outcomes and the worst case thinking gets us all, right?
Yeah.
And so I do like at times to say, can I talk to the other side a little bit? Let me have a little bit of discussion here, and to say, hey, here's my thought here. Again, my job is to try to educate you as well. And hopefully Carrie on the other side of the judge saying, no, this is easy, that when that comes back down from the appellate courts, then we're thankful for that, because if it's an open issue and then the appeals court says that was a mistake, now I have control in the jurisdiction that says the admission of an expert is a controlling issue that will cause a appeal of a verdict, and you can't do that. And so hopefully those appeals come back, and the appeals attorneys are able to argue in a persuasive manner why we need to be, admitted. And that's a problem for right now. Hopefully, leads to a longer term good. That's like, why we shouldn't need Bruin versus New York State Rifle and Pistol Association to have the Second Amendment respected, right? And shoot, the Heller case should have solved this problem. If not, McDonald versus City of Chicago should have solved it. And we're still, beating them back with a stick about it. But the wheels of justice turn slowly, but they absolutely do turn.
Yeah, that's true. That's true.
How about you? I want to hear about a case that you had that had some stink on it. My goodness, we've been talking for 20 minutes and we haven't even talked about your cases.
Okay, so stink. So I'm not going to necessarily say that because I have some cases that have not been adjudicated yet, and some that are coming back on appeal. So I'm going to be careful about what I talk about and how I talk about it. But I'm going to say in general, a weapon that's disposed of is stink. If there is, if somebody flees, that can be stink also. A past criminal history, even as a minor, juvenile, that can end up being stink too, because it's kind of like once in the system, kind of looked at. Go ahead.
So let's talk about that too, because of course, if we get to court, the Rules of Evidence 404 should omit previous bad acts, but the prosecutor gets to know about it.
That's right. That's right. And when they charge, can often be based on that. Even, and all kids do dumb things. There's a reason that we seal juvenile records, and they're not, part of future adult cases. At least shouldn't be, as far as prior fact goes. But it's just kind of interesting to think of, really, that a charging decision might be made based on that, or even the investigators might impact the conversations they have with the prosecutor while they're still on scene and gathering evidence, because things like that happen.
I
Okay,
mean,
so let's
we
get to
had
some
the
of the
case
really
that I
weird
had out of
ones.
Michigan. Failure to call 911 was
Yeah.
a significant factor in charging decisions. Why? Because in a cop's mind, in a dispatcher's mind, in a prosecutor's mind, the victim calls cops. And if not, you're the scumbag we deal with all the time. And then that gets taken into account with charging decisions.
Yeah. Yep. And for police officers, I mean, God bless the men and women that do that. The segment of society that they deal with over and over and over again. I don't know how it's possible to not become jaded in some areas. I know they work very hard not to. But if it's one person that you've dealt with before as a juvenile, and then you see this happening, and then there's small little things that wouldn't necessarily add up altogether in another situation, but in this situation they do, because of maybe they had interactions with them as a juvenile. Or maybe a family member said something. That's a huge stink that I find on cases, is what the family members will say, whether it's at the scene or to detectives later on. Even utterances like let's move out of here, move out of there. What the individual was talking to is, let's just move from where we are here and get out of the flow so that we're not in the way, so that ambulances and fire trucks can come by. And when a family member repeated that, let's move out of here, to the police officer, what's on his body, it looks bad that, here this family member is saying that the individual said, let's move out of here. That's not what they meant. They didn't mean flee. They meant let's move out of the flow. So just those little things can add up to a lot and can result in a charge.
So this wasn't a case that I
Or
was
decision
on,
to
a
charge.
case I know about, and it's a famous one here out of Mesa, Arizona, which was a shooting of Daniel Shaver by Officer Philip Brailsford. He had a dust cover on his AR-15 that when you open it up again, adult words coming, so adult things going. That when it opened up, it said "you're fucked," and a lot of people are like, "See, there's a problem right there." Well, the reality is that stink, man. That puts stink. Those kind of cosmetic modifications, and that could be a dust cover like that, a Punisher skull, a Spartan helmet. I mean, goodness sakes, any kind of a political statement, those kind of things. So I know for a fact. Here's the thing: that dust cover did not get to court. It did not make it into court. It was considered prejudicial, which was the right answer, quite frankly. Okay, yes. But it cost the defendant, it cost Philip Brailsford about mid 5 digits to keep it from happening. So I'm talking tens of thousands of dollars, not tens of thousands of dollars worth of motions in limine and wrangling back and forth and pretrial hearings to keep it out of court and to get them to electrical tape it over when the gun was showed to the jury. And because why? Because it puts stink on things.
Yep. I know a case, not my case again, where the color of the individual's firearm was a huge factor in charging, because I know somebody that worked in that prosecutor's office. And the reason was because it was just an uneducated situation, and that the thought was that it was dangerous and reckless to have something that looked like a toy, that a mother should have something that looks like a toy when she has children around. That could be confusing to the children. And so her behavior, was reckless. That wasn't the only reason why it was considered reckless, but that was one of the things. And that didn't make it to trial, of course.
Was it like a Tiffany blue, or was it something like that?
This one was pink. This one was pink, very pink. Yeah. And it had some Cerakoting or whatever done on the slide as well. So it was pink. So anyway, it's just weird. Some of the little things that can cause so many problems, even in a justified use of force situation, when that time span is justified, but some of the actions beforehand or misunderstandings, right? That's another part of it too. And a huge job is educating. That's one of the things people ask me all the time, like, well, don't the attorneys understand self-defense law? I'm like, not only do the attorneys, at least the ones I've worked with, have not understood it, the clients don't either. I mean, I remember I had to explain to a client why, in my opinion, his case was not a justified use of force. And I explained the parameters of that. And, I went through it quickly. I had a little flow chart to show him. And he said, well, can you write that down for me? I've never heard that before.
Wow. Yeah.
And
I
it's
mean,
like, oh my goodness. I mean, oh,
I
it's
literally,
sad.
so I'll tell you about a case that is, I don't know if it's still ongoing, but I had a man email me directly and say, John, here's the video of my use of force, of me shooting a guy. And would you help me with this case? And I'm like, well, first of all, your attorney is the one who should call me, not you, and contact me. Number two, when that video gets disclosed to the prosecution, friend, you should take whatever plea it is that you could possibly take. So again, people don't understand self-defense law. They just don't.
Yeah. Yeah. And sometimes they often think they do too. I know I've had a couple of cases where they subscribed to a certain type of training that would come in the mail monthly and or bi-monthly, whatever, in the form of a magazine type publication. And so some of those things would be read. But what was, taken from those, what was extrapolated as far as information was not even close to what was intended to be communicated. So people will sometimes feel like they're getting training. And in some cases, it's all they can afford. They literally cannot afford to do. And I don't mean, I live in a part of the country that's, little backwoods and down home kind of thing. And we have, people that live off grid, not necessarily actually folks I'm thinking of not by choice. They don't have a choice but to do that. They can't afford to get water and power up where they live on their property. So anyway, it's sad. They attempted to get training, and yet what they got ended up getting them in trouble because of what they incorrectly thought.
Yeah, and listen, here's the big thing, right? Is that the law doesn't care what you understood. The law cares what it is and whether your actions were in line with it. Full stop. And that's it. And so a big part of this here is to be a good, sane, sober, moral, and prudent person. And those things that put stink on them, I want you to recognize, number one, those get used in charging decisions all the time. I mean, all the time. They end up in court. And when they end up in court, man, you get the book thrown at you, and it makes you look bad when you get those stink. We had, the case, very famous case of the guy that ends up in a shooting with a bunch of guys and then goes home and orders a pizza and doesn't call the cops. And you're like, dude, that's what every prosecutor learned in law school. That's what they call mens rea, the evil mind, right? Like, you intended to do wrong. You knew you did wrong. And so you covered it up. You ran, you hid, you didn't get help. And those kind of things end up costing you your freedom. They end up costing you tens to hundreds of thousands of dollars. And so those ones with stink on them, man, you just don't do it. The less stink, So I had an attorney who I respect say, listen, an attorney is nothing but a cook, right? And whatever ingredients you hand them, they have to cook up and serve to the jury. And the prosecutor first, right? So we're going to talk to the prosecutor about what we think happened. They're going to talk about what they thought happened. We got theories. If I can convince them my theory is plausible, maybe I can get them to leave me alone. But if you hand them filet mignon, easy to cook up a filet mignon such that it's easy to eat, right? But if you hand them a sack of hamsters, well, guess what? Now I got to convince this guy or this jury that hamsters are nutritious and they're low in saturated fat, and a healthy diet of hamster is really good for you. And that's a tall order. And I got to make hamster delicious. I don't have any idea what hamster tastes like, but it's a rat, so it can't taste great, right? So, hey, if you serve up hamster, then guess what the jury's eating? Hamster. And so, you want to hand your attorney filet mignon, not hamster. And so, man, Carrie, I think we could talk about this for hours. We've been going long enough already. I really appreciate your expertise in this.
Thank you. It's fun to talk. It really is. I like talking about this stuff. I learn a lot too.
All right. Goodbye, everybody. Have a good one.